Okay. So I did exactly what you said. I went in and I only used mine. I didn't even enter into theirs. So
Right.
I can show you that and proof of that. I'll show you my proof of that. Just so I can get you up to speed of where I am. So I went into the court all right, here. Can you see this one here?
Yeah.
So I went into the court very naive, and then what you'll see here, these are all my cases. So there's me 1, there's me 2, then that's another guy, that's not me. Then there's me 3 here, and there's me here at the New Zealand Supreme Court, which is where I'm sat now. And they've linked me up to this original Naturalisation Act of 1844. And there's another one in 1858, which is connected to another bank as well. And so when I went into the court in the 161, here, I went in with my prayers, but I went in with 4 prayers. And I brought in the Electoral Act, which my original tenancy agreement said no foreigners could govern in our parliament. And in their secondary agreement, they said that the foreigners can govern. And so we've got Iranians, we've got Somalians that have been in New Zealand, a New Zealand Somalian who'd been in New Zealand less than 10 years. And he was a refugee.
Again, I want to point out, it doesn't matter. Again, that's a whole different, just think it's like a whole different country. They're dealing with a separate law. It doesn't matter who's doing what, who's on first, what's on second, because that is something that they've evolved into, and it has nothing to do with what you want to do.
But it's repugnant. It's repugnant because in my agreement, my tenancy agreement,
to understand how the law.
But in my tenancy agreement, I have free speech and I have the right to speak freely. In their tenancy agreement, they added a law years later saying that if anyone in New Zealand insults them, such person will go to prison for 3 months. It's repugnant.
Okay, it's not. So it has nothing to do with you. If you're on the right jurisdiction, we're dealing with a matter of jurisdiction here. Subject matter and status create the jurisdiction. It doesn't. None of those laws apply to you. And hence, I put lies there. But the fact is, they have put in a parliamentary system that was with their right that evolved into where it is now. They're doing it according to law. Whether you like it or not, it doesn't matter. All you have to do is focus on, Kate, is you've just got to go to what is your interest. That's it. And there's other people that are happy with that way the system is. They'll continue on. They're not going to argue. They're not going to debate. Let them. Everyone has free will. And this is another thing. You have absolute free will. That can never be taken away from you. You're only subject to how you talk in your agreements. So if your agreement is predominantly on that subject that you continue to revert back to, stay on that subject. Thereby, all those laws, all those agreements come into effect. The laws if you're not listening to you, that means you're in the wrong jurisdiction. Just it's simple to say, okay, Your Honor, there's a misinterpretation of what I'm trying to get past here. Maybe it's my fault, or there must be a misinterpretation of the law. The fact is, I'm dealing with this subject matter. That's it. Are you in the right jurisdiction to hear me in this in relation to this subject matter? Yes or no? We've got to keep it simple, because when we get all of our feelings involved and we throw in other verbiage in, we tend to convolute things more, and then we lose the true meaning while we're in court. A well-known lawyer that became a teacher within how to write appropriate documents and so forth, he said, and made it really succinctly, he took 2 paragraphs that were all convoluted, like old English law writings, okay? And he said when he got done with it, it was just subject, verb, object. He says if you want to discuss something in court, subject, verb, object, subject, verb, object. Just break it up in sentences. That's it. And the reason why lawyers won't put it that way, as he actually said himself, was because we would never get paid. So the reason why it's so convoluted is because that makes it difficult for the average layman like myself to even ascertain what the hell they're talking about. So when you're talking, just go to the subject matter. If you need to be, if there's any question to say whether you can deal with that subject matter, then I am sure you'll go to the Interpretation Act, or one of your acts there that will predominantly say that only of the same subject matter can be repealed. You can't repeal. They could never. That new tenancy cannot repeal anything of your own right. They can't. It's impossible because it's a different subject matter. They can't now come in and speak to your interest. That's what I'm trying to get to you. Just speak to that. You don't have to go through a lot of this. And it's, you went through a great history to find out, where everything is and how it got to where it is. But the reality, it's done through law, because by your very direction of pinpointing where they did this, did that, is not, there's a paper trail. That proves they did everything according to how they could do it. Your interest
But
is to say,
I think that the courts are listening to me by the very fact that they've put all my cases up on the official New Zealand law website, and they have not thrown me out. I'm still in there, but
yeah.
But I'll get to you, I know you're saying exactly correctly, because I'm going to the court and I'm saying, because for my one, because it does just say, unless you call it, they can basically do what they like until the subject turns up and says, I do protest through the bills of exchange. And if nobody turns up to protest, they can do pretty much what they want through the law. But when someone turns up to protest in their own place where they are, then they have to do something about it. That's when they have to recognise you. So if you're not standing there, if nobody's standing there protesting the said bill, then they can do what they like, because nobody's protesting. But I am the first one that's going up protesting. They haven't thrown me out, but
I have a suggestion. Okay.
Yeah.
If you want to make sure that your point is clear and you're dealing with the correct subject matter and what you want to deal with, I would right now form a letter succinctly and try to get down to 1 page, maximum 2 pages. Okay. And you're going to go and write a letter to the Attorney General and say, I want to include you.
No, because I've called in. See, when I originally went in, they said to me, what the Crown Law and the Attorney General said is that we're not coming. They said, we don't recognise you. And then they said, we're not coming, but the appeals court said, you have to come. And so that's the Prime Minister, Jacinda Ardern. Chris Farfoy was the Minister of Elections and stuff. Andrew Little and Ashley Bloomfield. These were 4 the key ministers. And then the Crown, I called the Prime Minister herself. They all said, we don't recognise you. As they said, we're a corporation. They basically said, we're a corporation. And as a corporation, you have to be an attorney. But the appeals court said, no, you have to come. And so they sent a letter, and then they said, yes, we will come, because the appeals court said, you don't have to come if you don't want to, but if you don't come, we will carry on this case with this subject without you. So they sent a letter and they said, we're coming. So they have recognized me in my subject status, and they have recognized my right in my subject status, because in my subject status...
Well, can I ask you a question? If they recognize you, do you have a determination that recognizes you in that subject status?
Yes.
Because if you do, then it ends. So
no,
then you deal with it.
That's why that's why I need you to this is where I'm at the point where I'm trying to show you, because if you see in the legislation, when you look in the legislation, you'll see the 1688 will. They call it the bill now, but it was the original act. The proper act is called the will. And if you see, I'll have to wait for a minute for it to come out. Might be able to go into this one. Hang on. So what we've got here is the 16. Oh. The 1688 will. Oh. The 1688 will does not show up here. Why? So the 1688 will is, they've put up blocks. All right, here. So this is the 1688 will, which the Supreme Court is sat on the English will. So under this will, it says here, so here's this AB that I was talking to you about, which is on the bank and which is on the bills of exchange and all of that. And this one says, I do declare that no foreign prince, person, prelate, state, or potentate has or ought to have any jurisdiction, power, superiority, authority, ecclesiastical, or spiritual within this realm. The realm is me, and they have no power over me in regard to these rights that I have. And then that says the subjects' liberties are to be allowed. And then this is to the Lord spiritual and temporal and commons in Parliament assembled for ratifying, confirming, and establishing the declaration. I've asked for a declaration to affirm my liberties and my right as being paramount to me, not anybody else, but these rights here being paramount to me. I've asked the court to give me a declaration to confirm that I continue to be permitted to stand within.
Okay, have you got that? Have you got that?
The judge said, you're not a subject, you're a citizen, and I'm challenging him.
Okay, so then you've not got, then you can't go forward. So you're jumping ahead to another issue without getting that first requirement dealt with. That first requirement is based on the jurisdiction of that subject. And you've got to be able to be, you've got to be determined as that subject in order to have that right.
Exactly.
You're saying that the court has not yet identified you. So that means you've got to get that done first.
Yes.
Now, so why don't you do this is what I would do at tryout anyway. I would go and write to the Attorney General and say, I want to bring you Actually, I don't know if now, because you have another action against whether you can do this.
Yeah, wait. I'll just show you this, and then I'll show
Because
you
you
the
might,
other two actions.
no, but
Um,
the point is, we got to bring it down to the nitty gritty, and whether you show me more and more details of what that act says. If you're not subject, the act doesn't mean anything. Now you're thrown into the subsequent tenancy, and that's where you're being spoken about. You've got to create through a civil action to the judge to make sure that you are correct in your status. That's first, paramount. Now you can talk about what you want to talk about pertaining to that subject matter. But right now, you've got a couple of commingling going on, so they're automatically going to throw you into the equitable subject matter, or that subject matter that is now that you don't even want to be a part of. Like I've said before, it's imperative that you get that done first. And that if you said that you've have not met that requirement, then how can you speak to that requirement with the other parties? I'm not sure how that judge is saying. I'm not sure how that judge is saying that he's going to include the other parties, give you leave to get the other parties in, and without now totally eliminating your power because you haven't yet determined your status. So I don't know what he's doing, but he might be to set you up for a fall here, because you haven't got that that matter first established.
That was the original prayer that I went in. The original prayer that I went in was to be declared to be a subject. I said I do pray a declaration to the effect clearly stating the applicant's ancient 1688 subject right under Almighty God exists pursuant to another law called S28. So I have asked them to give me a declaration to declare my subject status. That's what my original case was. And I had to give them, you have to give them a cause. You can't just go in there and say, I declare myself a subject. You need to have a cause that caused you the desire to wish to go to stand in your subject status. What is the thing that is repugnant to you? What is the thing that is caused you to have stress in the tenancy? So I put the causes in there.
I don't even get that.
So I asked to be declared.
Matter, so you have a right to that subject matter, Kate. You have a right to subject matter. No one can tell you don't have that right.
Well, they did, because he said,
if you're commingling.
He struck me out based on so he struck me out based on recent subordinate laws where within the corporation, and he struck me out under that. I put my grievances of the Parliament, and I said to them, I'm not wishing to address any of the issues. I'm only wishing to have a declaration to assert my subject status, because if you look here, they put in this 1990 in the new tenancy. The new tenancy has got this 1990 Bill of Rights. Hang on. So the new tenancy, which is a 109, which is clicked onto my tenancy here, in the new tenancy, these are all attached to the UN. This is the United Nations tenancy. And if you look at section 19, there's no United Nations or anything on there. And if you go right down here to S28, it says all our existing rights and freedoms will not be abrogated nor restricted by reason only of this Bill of Rights. So that is saying that our first tenancy agreement is outside of the second tenancy agreement. So that's all within the law, right? So that is correct. So they've said it right there. They've said right there, your agreement is nothing to do with our agreement. You're outside of it. So they said, we're not going to affect you. So that's fine, right? But then look what they did. Then so over in here, in their 1990 agreement, in their tenancy, it also has a New Zealand Bill of Rights, which is not the correct one. And over here, in this one, if you go down to section 19, they inserted the Human Rights Act of 1993. They inserted it into here, which was not in the original one, which is connected to mine. It still has my rights are not affected, right? But then when you go into their tenancy agreement, which is the Human Rights Act 1993, when you go into their tenancy agreement, I can't. They've blocked me from New Zealand law sites, so I can only get into this one. But has it got it? 1993. Yeah, it's got it here, so I can get it in here. If you go to the Human Rights Act in their tenancy agreement, and then you go to I have to go down quite a bit. If you go down to section 5, and then you go to KII, it says there is a desirability of New Zealand becoming bound by any international instrument on human rights. And coming with that, they've given themselves all sorts of rights, which are all to be paid for by bills to us. So I wanted to use my 1883 right to protest their hundreds upon hundreds upon hundreds of bills that they are passing through Parliament every day, and all those bills are to be paid for by the first tenants. So I first went to the court to claim my subject status. And so get out of that, all of that. So get over here.
Can I interject? Just hold on for a moment, okay?
Yeah.
I don't have much time. I didn't realize how much time we're going to spend here. My point is that it still remains. You went in initially to have ascertained and determined your subject status.
Yes.
And to what you're saying now, it hasn't been done. To which then throws you back into your presumed subject status, to whereby you're fighting a whole bunch of subsequent acts that happen under the new tenancy, which is none of your business at this point as a subject until you're there to see how you could affect that, but you can only affect that with other people that are on the same interest as you. They are running accordingly to where the ship is steered. They are going in that direction. In fact, and I keep on saying to everyone else right now, they're moving from a third level of a trust to a fourth level. That is where they have to go because their lease is up, whatever the agreement is. Don't want to get into all the details, but the fact is they've got to move. They've got to settle things, and they're going to create bills in order to create and to realize that settlement. Now, that's completely different than what you want to deal with. You're commingling, you're bringing back in what they're doing. It doesn't matter. You've got to deal with your interest first. That's why the judge he can't help you because you haven't yet brought in the primary issue, whether you discussed it or not. Remember, like I said, you cannot now assume that the determination is already made when the determination has not been granted to you that they understand what your subject status is. You've got to get that determined no matter what you do from now on. That is what you've got to do. And you are not going to, you should never, bottom line, it's up to you whatever you're going to do, but you should not move on to other issues because it's a whole different dynamic. As the court creates, each issue has to be solved according to how it's presented. And until you get that solved, just stick with that. Nothing else is going to work in your favor, to which they may just be setting you up right now and drop the ball because you've brought the parties in to witness that you have not been speaking to the right interest, which is a different subject matter than the one that Arden is dealing with and stuff like that. They're dealing with a whole different, like you already alluded to, a different tenancy. It's just different. Just get that that foundation in your mind. It is different. It's like opening up and cutting New Zealand in half and starting a new country. It is different. So that's how I would focus on what, in order to get what you want to be done and to be heard, is to just deal with that primary issue, which is your status. And if you just stick with that until it's resolved, they cannot tell you, if you bring in the law, they cannot overreach the law in order that you brought in, if you are bringing the correct law in order to get that determination, and to which there's a test by it. So what I would do is go through these videos that you've recorded and see how I brought back to the same issue all the time, where it is that primary situation of getting your status determined. The status is with you, just like the dominion right is with you, Same with the common law or the English law being your birthright. All these things are still in play, but they become repealed if they're dealing with the correct subject matter, or another law deal with a different subject matter to an interest in property is brought in, and then everyone shuffles over to that side. It's like, shuffle over to the side of the boat. Now everyone's dealt with in that manner. It's a sleight of hand. Okay, I agree. But there's no deceiver if there's no one to be deceived, right? And ignorance of law is no excuse for violation of the law. So it's the assumption everybody knows the law and they're making their own choices, to the presumption now creates the verdicts for them to move on, because it has to go on the pretense and not to impede the law that everybody knows what they're doing. That's free will. You're making your own agreement. You're going into this new tenancy agreement. You've made it. I've seen your actions. You made purchases under it. You bought legal titles under it. You did all these things. It shows that you are. Regardless if you saw the sleight of hand, but at the same time, was it available for you? Is it still available for you to get back there? Yeah, it's like the Hansel and Gretel story. The breadcrumbs. You've got to get back to the primary spot. Now, from there, I would then execute what you want to do next. But you can't.
So that's what I need to ask you, what I'm going to do next, because here's what happened. I went in and I asked to be declared in my subject status. That's what I was trying to do. And then they struck me out. They said we're a corporation, and under corporation, the
you applied to the wrong court.
They said something. But anyway, I went to the appeals court, and the appeals court said, you have to come, you can't deny her. But then they hit me with $7,000 security fee, which I would lose even in the event of winning, and also the scheduling fee, which was scheduling fee about $3,000, which to me was worth paying to get the Prime Minister into court. I thought, well, I only wanted to prove that I could use the Bill of Rights to bring the Prime Minister into court. That's all I wanted to prove. And the $10,000, I have it in my bank, and it was worth it. But I felt that I was betraying my subject status, because it says in there that we have the right to petition the King, and all prosecutions and commitments for doing so are illegal. So I protested that fee. The court registrar said to me, we only are looking at why you were struck out, and not the original plane that you were flying in on. So they said that plane is irrelevant. We're only looking at, and I felt that it was wrong of the registrar to only recognise his pilot and not recognise my pilot. So I protested, because I said, well, you have to look at both of the pilots, you can't just only have one pilot. You have to recognise why the first pilot went there in the first place. And because if there was not I flew the plane in, and he got onto my plane. And then she threw my pilot out and only recognised his pilot, and she said, the determination. So that went to Judge Brown, right? And then, so that went to Judge Brown. I'll just let you know where I am, because I know you're going to tell me the best advice here. So that there went to Judge Brown, and that was my first case there that you saw, and then that went on to Judge Brown, and then under Judge Brown, he this is at this point in time. Judge Brown, this is not the rule, you can't see. This was the analogy of my case that the New Zealand Law Society did. So, but here's the actual thing that he wrote. He basically said, you're not a subject. He said the naturalisation of German settlers in New Zealand, he said that you can bring proceedings in the court like any other citizen. So he put me in the citizen and took me out of my subject. She's not exempt from fees, because she's a citizen and not a subject, which is what I was trying to get into my subject status. That goes to what you were just speaking of, that I'm trying to get into my subject status, and he said, no, you get out. So I appealed him to the Supreme Court, and this is my Supreme Court, and the Supreme Court was lovely. Because when I got to Supreme Court, they said, well, if you want to take him to court, you have to pay us $1,000. So they said, yes, you can go in and fight him, which was really good, because I get 15 minutes to speak. He gets 15 minutes to speak, and I get 5 minutes to rebut him. And if nothing else, I don't have to pay the $7,000, and I can drop the case, and I still get to fight to claim my subject status. So that was the fight is right there. The fight is me against him. Him saying you're a citizen, and me saying I want to go back to my subject status. And
so are you saying an error on the judge? Is that what you're looking at? The judge erred in his decision?
Well, it's yet to be determined. I'm saying that he did, and the court and the Supreme Court. So the Supreme Court, so then they wanted the registrar of Supreme Court. So that judge of appeals court is already in Supreme Court waiting for me. So he's there waiting for me. And then the registrar asked me for $1,000 to file the case. And I came back under my subject status and I said, it is my right to petition the king. So the Supreme Court turned down my ruling, but the Supreme Court said, and I'm grateful, the consistent theme of the submissions is that the right to petition the king under the Bill of Rights, 1688 Imperial, provides a right to petition without being subject to fees and costs when petitioning the High Court on questions of law. So they have refined it very nicely, but they declined it because of the first case that removed my original pilot and only put in the first pilot. And they said we only recognize the second pilot of the strikeout. We don't recognize the first pilot of why the strikeout, which was actually using my subject status. So they removed it. So there's a bit of thing going, but the good thing is they said the application for the review of the Supreme Court fees is dismissed, but they said if the applicant wishes to have the application for leave to appeal accepted, you must pay the filing fee. So they said, yes, you can come to court. So then I wrote them a letter and I said to them in my letter, so I then wrote them a letter which is here, I hope. Right, so I wrote them a letter and I said to them in my letter that I said, so it was Greenhow that originally gave me the fee. So I've put it, the BOR, which is the Bill of Rights, versus the BORA, which is the Bill of Rights Act, which is the secondary tenancy. I'm the first tenant over here. He's the second tenant over here. And it really is a battle of the tenants. So I said, I'm considering applying to the Judicial Committee of the Privy Council for an appeal as of right. I will be asking for a declaration of right to petition the king under the Bill of Rights in the ancient law, and as a matter of question asking, does the strike of an originating declaration of right of application abrogate the will of right to petition henceforth to prescribed schedules of the Court of Appeal fees regulations? So what I'm saying is, when I went in there asking for a declaration to be recognized as a subject, he basically struck me out and said, we don't recognize you as a subject. Then the appeals court said that they will only look at if the strikeout was legal or not. And then they charged me fees, and they did not recognize the right to petition freely, because as you have graciously pointed out, I'm not recognized as a subject yet. So how can I use that you've only just made me realize that. How can I use that subject status when I did not get recognized in that court as a subject just yet? But I thought the appeals court should recognize both pilots. And so then I said, I want to go to the Privy Council and ask about this. So this is where I'm sitting now, David. So they sent me a letter back And then they said the Supreme Court they dismissed the application for a review of the decision declining the waive the filing fee. And then they said it was ordered that if the applicant wishes to have the application for leave accepted, you must pay the filing fee. And then they said, in your email below, you have requested a 3-month extension. So I've asked them to defer. I've asked them to let Judge Brown sit there for 3 months while I go to England to try to claim my subject status over there. And they've said there's no provision. So if there's no law, then there's no law. There's no provision in the Supreme Court rules to extend the time for payment of filing fee in these circumstances. So they said your application for leave to appeal the decision of Judge Brown, which is the appeals court, that one of the strikeout, will be accepted upon your filing. So they basically said when you come in to file your submission, you can explain to them the delay in the payment, and then that will just go into part of your case that's accepted for filing. So that's what they have said. So then after that, so we've got Jacinda Ardern there, and she's been called in based on the strikeout, and then that whole thing changed to be a fight about fees under the right to petition as a subject, which you have clearly pointed out that I'm not in that status yet. And then that went to Judge Brown. So Jacinda Ardern is sat in appeals court waiting for me. Judge Brown is sat in Supreme Court waiting for me. And my next endeavour is to enter England to try to claim my subject status there and then come back down. But you'll be able to help me more. In the meantime, just quickly, the appeals court has said, they have said that we will consider your case abandoned unless you do certain things. So I've got to go back in there and reclaim it as not being abandoned. So I've got to get back in there, and she's given me the various court rules, and one of them is requiring of a $400 filing fee, but it's still, which now she has said I have 20 working days to appeal this decision. So basically I'm getting very caught up, because I can then appeal that decision to a new judge, and then that will go to Supreme as well, were it to be declined. And so I've got all these places. They've given me many yellow brick roads to go down. But it's like, which door do I open here? I'm not in there just to fight cases for the purpose of fighting cases. I'm in there to achieve a goal, so that if we have our subject status right to petition without fees, anybody that wishes to stand in there can call Parliament to court over all these bills, hundreds and hundreds and hundreds of bills that they're getting in the second tenancy, which is being passed on to the first tenancy, by the way. First tenancy has got to pay all those bills, not the second tenancy, because they have written laws in their second tenancy that they don't have to pay. That the first tenancy will pay. So we need to be able to go and protest these bills. So I've got these many roads to go down, David, and that's why I've asked for your expertise, which I know that you did not intend to be dragged down all these roads. But I'm so confused.
That is a longer approach to get to the crux of this issue. And there is, I mean, it's pretty obvious. They're just, it's like, you know, the idea of playing court itself. They're just playing sort of pig in the middle, and they're playing with you, okay? And it's sad that they've got to that, you know, that realm, that they think they're so morally or lawfully superior that they treat people like this. But that's who they are. We can't. We've got to battle with who we are first of all in order to deal with the matter at hand. And if you have a right, so right to catch-22, if you have a right to petition the Crown without paying the fees through, you know, merchants and so forth, then you can only have that right when you receive as a subject. But they're not allowing you to get to that point unless you are a subject first, to which then you got to pay fees in order for that to happen. So I think that the pressing for the court is for who that has asked of you to get a determination now, which I think, well, we call it a, what do you call it? Instead of going through chambers, what is that, petition, or do you remember what that was? No, what is it? Whereby you just set your questioning to get determined before a judge who doesn't even see you. He doesn't see the other party or anything else. He just makes a clear determination based on the information that you brought into him, okay? Or requisition. Well, that's what we have here. It's called a requisition. So we would do a requisition in court to which meant you're not stand before a judge or any other parties are involved. You're just going to get a question asked. Now, is there a fee? Well, unfortunately, because you're not subject when you're asking the question, yeah, there's going to be a fee, okay? Which, you know, it's pretty menial around here. It's not a lot of money, but you know, a lot less than the 400. I think it's probably less than $200 here. So you would then have to have determined, is a subject based on the tenancy granted, and you know, you're going to go to the bill that's stanching that right. Are they with the right to petition the Crown without paying fees? Okay, so whatever that question is and how you want to address it. Okay, I'm just taking off the old top of the block here. But you want that, if he says yes in your favor, yes, they do. Okay, so now you've got that established. So what is the next issue is, of course, to get the subject status. So where they're playing around, well, you got to pay a fee in their system in order to be ascertained as subject, which is sort of like an oxymoron. It doesn't make a lot of sense. So how would you approach it from this point on? And I am not with the fortitude to really address that question absolutely, because it's a quagmire. The way that I would have handled it would have been different, would have set the stage differently, but that's what I'm doing to make it simpler, because I see all the traps, okay, that's laid out for us. And the more that I can actually deal with those traps with reasoning, to which then corners them into a response that if they make that response, it would look ludicrous on their end to say it if I wasn't able to do it. I'd make sure, it's like a lawyer before he goes to court, before you ask the question, make sure you know what the answer is always going to be, okay? That's what you want. You want to make sure that before you address anything that you already know the answer. So
I told that to the first judge and he recognized it in his ruling. He said in his ruling, when I put the causes for my concern, and I said to him at the case management, I said to him, I'm not coming to address, I've put those issues that are the things that are causing me stress, but first of all, I'm coming to claim my status first, to determine my status as a subject, and then in my next step, I intend to address those issues later. And he recognized that in his court, and he said clearly she's seeking a declaration, clearly. So he recognized all of that. And then he just said, but no. And yeah, but
no.
But I've got...
Well, because there's a commingling. Somehow you're commingling something.
He commingled it. He commingled it with the corporation. The Crown Law said, since we, the government, are a corporation, and by a law that had been recently been created called the, I can't remember what it's called, but a specific law where a corporation, nobody can go to prosecute a corporation without having an attorney. An attorney is the only person who is permitted to do that, because because of the equality. If the corporation was to go against a single person who did not have an attorney, then the corporation would be seen to be over-advantaged over that person. So therefore, in the corporation, the person must have an attorney to fight with the corporation's attorney, so that they were fighting on an equal basis, so that the person could not come back and say, well, we had an unequal status here. So that was what they threw at me. But I said...
Okay, so that's correct.
So I said, well, so that's in the commercial, but that's not when we're only talking about a declaration of right.
Right.
Not talking about monetary things or anything like that. Because our right comes from God. And so God doesn't need an attorney, does he?
Well, you know what? I would not be using the term God, unfortunately, because God is to the interpretation of whoever you're dealing with, and that creates a whole... I would use rule of law more than the idea of God. And then if you use a rule of law, then there's always something subordinate, because all English law is a hierarchical system of landholding. So there's always something subordinate and something primary. So rule of law, you've got to go to the rule of law that allows you to now ascertain your right of being subject. They can't force you into the other tenancy, because that's involuntary servitude and slavery. So there's somehow that you're saying something that when you bring something into court, you're automatically bringing in the other tenancy, whereby if he's speaking to two things, you're speaking to one, he's already assigned you over to the subordinate tenancy before you even speak.
Yeah, they keep putting me in there, and I don't want to be there.
Okay, there's something that
I want to get out of it.
Okay, so search in your own case law to find out there's got to be something that you're saying that's allowing them to then subvert your interest into that lower interest. Now, I have to say, I got to get, because I didn't, 7 o'clock, I was already late, and it's already 15 after.
All right.
Okay, so
maybe we can come back in another time, because I just wanted to, because I wanted you to give me advice on which yellow brick road I should take.
and here we go. You see, as you know, I teach something completely different. I don't deal with all that subject stuff, and that's fine. I mean, everybody has what their purpose is, and there's nothing wrong with what you're doing in the way that you want to do things, because you're right. You're correcting something that's overlooked as an overreach, and you're wanting to correct that, and that's valiant, and that's great, and everything else. Okay, so I would not. What I'm doing, just a quick synopsis, is that I'm doing the same thing as you are. I'm making sure that there is no way that when I go and deal with the court, I'm not inadvertently bringing in the obstacle that will then put me into a subordinate or lesser right. And that's the most difficult thing. It's going to be easy. I know it is. So divinity is simplicity. They will know, it's the way that I'm thinking it. But it is that I got to be able to come in and not be them pushing a right on top of me, because they would have to prove that they have that right in the first place when I only deal with a certain subject matter. So if I come in with the subject matter that I want to deal with, which is a common law interest held in right of the monarchy, then here's the act I want to use, the Settle Land Act 1925. There's my warranty, and that's it. And if for them to speak to a subordinate one means that I'm obviously in a wrong jurisdiction, or they're trying to, trying to fish me out of where my interests are and see how strong I am in my standing. But I'll know, because I'll know the different interests are speaking. As soon as they speak, I'll know, oh, you're not speaking to what I'm speaking about. So obviously, that interest that I want to deal with is not going to be heard in this court. Therefore, I need leave of the court in order to deal with that. Like, just continue it on until I get to a judge that's only going to speak to that matter. So,
because I'm hoping to get back.
I'm doing it different.
I'm hoping to get back to 1841 and unplug myself.
Yes.
I've got to get back to there first. And then my intention is to unplug myself because I'm not happy with the second tenancy. So I want to unplug and I want to take all of my trust with me. My portion.
But
that's mine.
At the same time, to just as a cautionary thing, as a caveat, I wouldn't be disclosing that you want to now attack the other side, the other tenancy, because that will raise flags for them to then thwart you and play around with you, what they're doing now, and because they don't want that ever to be established. They want to keep on playing the game for as long as they can play it until they get their needs met, which is happening with this whole COVID, or this whole scam.
Exactly, because it was all done through the second tenancy. None of it was done through the first tenancy because it wouldn't allow. No. They did it through the second tenancy.
Two separate subject matters.
Yeah.
They can't commingle. That one has nothing to do with the first tenancy, and this first tenancy has nothing to do with the second one. They're just trying to get you to speak about the second one. When in line, as soon as you do, now they fished you in. Okay.
Yeah.
Don't talk about that at all. It does. Forget it. Don't live wire it. Don't talk about it anymore. Speak to your primary interest. You've got to get that status. That status corrected, and you can. There's no way that they cannot stop you. They can stop you from doing that because it is already ordained your right, as is in everyone, to have a free will choice through law of domicile, your origin, your birth, or your choice of domicile. So you have that right. They throw you into that to give you that right to choice. Now you make that choice once you've aligned with the subject and got that interest, and only focus on that. Nothing else.
Yeah, right. That's very good advice.
Focus on that. But you can, and in the meantime, you can, as I said, that I forgot that name again. We call that the petition. What was the other one? Requisition. That's the word. I don't know why. I lose that. The requisition is what we do here. Is you're just going to ask a judge a question, and then he'll return his answer to you. So you may want to ask, under subject in the 1841 Act, blah, 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 is there any fees that I would have to pay as a subject, not, might not say as you as a subject, but as a subject would a subject have to pay a fee to have a question answered or make a declaratory right based on the act that you want to bring in. So it might be a simple question like that, keep it, and bring in the laws in order for him to make that determination. So if he looks, okay, you said here, and by what you brought me into the laws, I can make a determination on that. And he'll say, no, a subject doesn't have to. Whammo. So now you got that done. Maybe you might want to go, if he's responding positively, then maybe go into the next question, which is, how then, without paying a fee, do I get returned my subject status, as is my right? And based on, here's the criteria, bang, bang, bang. So that might be a way of doing it. Instead of going down their roads, this roads, and everything else. And now they're going to put statutes, they're going to put limitations on you with the other act. And I know it's their game. They're assholes in that way. But at the same time, they they got up, they climbed the line to be assholes. So, they've got that right. So I'm just saying, for your own sanity, look quickly to how you can ask a judge. I said, I got to get going. Ask a judge that question, whatever question you want to ask originally, but make it simple. Bring in the laws, support that so he can give a proper answer and determination, and then you're good to go. But that's how I would do. If the other things start to topple, I really wouldn't worry about it, because all you're doing is creating more and more binders to add more and more facts, and and they love it. But if that case goes to the side and you lost your time, don't worry about it, because your primary thing is becoming subject first. That can't be taken away. Okay, so it might give you some bit of a headspace, some room in there for that marble to roll around freely.
I think you're absolutely right. You've just cleared everything. You've just taken all that chaos and you've just downsized it, and you've just cleared the fog. You've just cleared all the fog and everything. It's like you can't see the forest for the trees, and you've really cleared it just with that. Just such a simple thing. I've just made to make, and I can go to England with that now, because I can show what he said. You're a citizen and not a subject. So he's basically said that. And so that is the catalyst for me to ask them to, I think, or I could go there. I think I still, like, if you've got some time to still come back, I'm only just asked the question, as I'm not sure. I could pay the $1,000 and I could enter with Judge Brown, and I could battle that issue right then and there with him in New Zealand. Or
you could, but I said he could be setting you up.
Exactly, that's what I thought. Or I could go over to England.
You pay $1,000 and they go, oh, thank you very much. We create another security. And we're going to say no.
The whole thing just topples. The whole thing will topple right there. So and it's just going to topple. I can just see it topple. But if I went to England and if I did what you just told me to do, if I left all of that out of it, didn't even speak to it, but just only spoke to my subject, wanting to be clarified as a subject, and then a small, simple sentence, putting up the laws that I've got there, which I've actually got more, which I haven't showed you, but I've got quite a few. There were quite a few agreements made back in 1841. Putting that up there, which was made in Westminster with the New Zealand company, and then just asking that simple question, can I, to claim my subject status, that I can continue to be a subject for as long as I choose, and also about the fees or something. But so I can just word it, but it's exactly like you've said. So I could, but I've already answered the question. I really need to go to England, don't I? Because that's where the agreement was made.
No, the courts are there. The courts are there available for you, whether in England or here. It's just just getting the right court, and it's all up to you. I mean, I'm not a lawyer or anything else. I don't deal with the legal world. I deal with law completely. I don't deal with all this other stuff that's in between. And for the very reasons that you're dealing with, it's just, they've got all the time to play, and they're getting paid, and regardless what you do and how you do it. And I've seen it myself, where they set the other person up and brought them right to appeal, and the answer was already there. It was like the appeal judge, there's three of them. He says, everyone be quiet. I'm speaking, just only one judge. And it was just, he allowed the petitioner to talk, but then right away, he already had the answer. And we didn't even have the information of where he got that right from the Attorney General in the first place to actually come into court with. He was already set up. So we paid our fee, and hey, he already had it done. It's like, I'm giving you your right. I can't take you away from your right to pay the fee and then get this determination, but I'll allow you to hang your own self. And that's what they do. So they'll give you enough rope. But in that case, I got to get going.
Thank you so much, David.
Good luck.
You're really, really wonderful. And, thank you for all your help. Bye-bye.
Okay. Bye now.
I have to turn that off.